Assalamu alaikum and good afternoon, everyone. Let me spend 20 seconds of my 10 minutes to congratulate SCCA and the organizers for putting together this excellent program and for thanking them very much for letting me be part of it. The topic I will address today is one that I think is crucial to institutional arbitration. So I thought it was particularly appropriate in an event which launches the creation of a new institution. The limits of party autonomy. We all know that international arbitration, including institutional arbitration, is the realm of party autonomy. The parties are largely free to agree on all aspects of the process. But the questions we are asking today is, are there limits to party autonomy? I have myself identified two sets of limits. One I will only mention today. We don't have time to go into the details, but is what I would describe as the outer limits of party autonomy. Since the selection of arbitration rules and of an institution to administer those rules is an expression of party autonomy, the parties, through this agreement, cannot achieve more than they could by a specific ad hoc agreement, which means they cannot violate overriding mandatory rules of law or public policy. And there have been cases in several jurisdictions, including arbitration-friendly jurisdictions, in which arbitration rules or the way arbitration rules are applied by institutions or by arbitrators have been considered to be in breach of public policy or mandatory rules of law. And these were breaches of fundamental principles of law, such as the equality of the parties in the process, non-discrimination, the right of access to justice, particularly with respect to impecunious parties, arbitrators' independence and impartiality, and the arbitral institutions and the arbitrators' immunity from civil liability. And this has led, in a few cases, to the setting aside or to the refusal of the enforcement of arbitral awards. But what I would like to focus my remarks today is rather a second set of limits to party autonomy that I would describe as the inner limits to party autonomy. And this is what happens when the parties refer to arbitration rules and so incorporate the arbitration rules into their agreement to arbitrate, but at the same time they also exercise party autonomy in a second way by entering into specific agreements, possibly integrating, amending, or derogating from the selected arbitration rules. Now, I must say at the outset that conflicts between arbitration rules and the specific agreements of the parties are quite rare in practice, and this mainly for two reasons. The first reason is that arbitration rules are not detailed codes of civil procedure. They are succinct sets of rules which set out fundamental principles with respect to the conduct of the proceedings, but are extremely flexible, and so leave room for the exercise of party autonomy permitted by the rules themselves. And the second reason why these conflicts between arbitration rules and the parties' specific stipulations are quite rare in practice is that the parties' specific agreement tends to prevail as lex specialis, precisely because the parties have specifically agreed to those. We should not lose sight of the contractual nature of institutional arbitration. And I'm not talking here about the contract between the parties, but I'm talking about the contract the parties on the one hand and the arbitral institution on the other hand enter into when the rules of the institution are adopted. Which means that if the parties purport to modify or amend the rules, this is a modification of the offer of services by the institution, and the institution remains free to refuse to administer the proceedings. Now, I think that all arbitral institutions have provisions of their rules that they wouldn't accept derogation from, fundamental rules considered fundamental by the institution, but I would submit that there is some lack of clarity by institutions themselves as to which provisions of their rules indeed can be considered as mandatory or as part of the so-called institutional public policy. And I'm here using the terms mandatory and public policy as misnomers in a way, because of course we are not talking of rules of law, but we are talking about an expression of party autonomy. The rules have a contractual value and not the value of the law. So what I've tried to do is to try to identify the provisions of institutional rules, or rather the criteria that may help in identifying institutional rules provisions that the institutions would not accept derogation from. And first of all, I must say that this may be different from an institution to institution. Each institution considers certain provisions of its rules as fundamentals. I've identified three criteria for identifying precisely what provisions can be considered as non-subject to derogation. There are provisions contained in institutional rules whose express terms exclude amendment. Second, there are provisions that reflect essential features of the arbitral process under that rule. And third, there are provisions which can be considered as part of the institutional public policy because they're aimed as protecting fundamental principles of public policy and mandatory rules of law. I have a few examples. You will forgive me if these examples come from the ICC rules, the rules of the International Chamber of Commerce I'm most familiar with, and with respect to which there is a lot of practice and of case law. Starting from the first category, which are provisions whose express terms exclude amendment, an example can be found in Appendix 3 to the ICC rules. This is Article 2.4, which provides that the arbitrator's fees and expenses shall be fixed exclusively by the court, the ICC Court of Arbitration, as required by the rules. Separate fee arrangements between the parties and the arbitrator are contrary to the rules. So the provision in this case could not be clearer. It envisages the possibility of separate agreements between the parties and excludes these separate agreements categorically. Another example can be found in what is now Article 1.2 and 6.2 of the ICC rules, which provide that the court, again, the ICC Court of Arbitration, is the only body authorized to administer arbitration under the rules, and that by agreeing to arbitration under the rules, the ICC rules, the parties have accepted that the arbitration shall be administered by the court. These were amendments that were introduced into the ICC rules in 2012 to clarify that only the ICC court can administer the ICC rules. This responds to an issue of policy, of course. Rules are tailored to an institution, so it would not be advisable for the parties to have the rules of an institution administered by a different institution, but it is now also expressed very clearly in the rules, which means that arbitrators and institutions who want to apply the rules chosen by the parties also have to apply these specific provisions and therefore abstain for administering arbitrations under the rules of the ICC or of other institutions that have adopted similar rules. Let's move on to the second category, provisions that reflect essential features of the rules. Again, as everybody knows, under the ICC rules, a very specific feature is the scrutiny by the institution of draft awards before these awards are finalized by the arbitrators and notified to the parties. Other institutions perform similar functions under the rules, but probably no institution does this in the way the ICC does. Therefore, the institution, the ICC, would not accept an arbitration agreement where the parties tend to exclude this provision, precisely because this makes the ICC rules recognizable and different from any other sets of rules. Another example, always belonging to the same categories, essential features of the rules, is the provisions with respect to the screening of requests for arbitration by the ICC court. Again, this cannot be excluded. In this respect, I would also like to point out that what we call institutional public policy is an evolving notion, because it may change in time. What an institution considers as fundamental at a given point in time may, in a subsequent version of its rules, not have the same nature. And this applies, for example, to the terms of reference under the ICC rules, or to the communication of reasons for the institution's administrative decision. In the past, these were considered fundamental principles of the ICC rules. In the more recent versions of the rules, they've lost this nature. And finally, the third category I mentioned, provisions aimed at safeguarding public policy and mandatory rules of law. This applies, for example, to the role of institution in appointing or confirming arbitrators under their rules. There is a French case, Samson Kimonda case, where French courts have recognized that the institution's refusal to administer proceedings in a case where the parties had excluded the ICC provisions with respect to the role of the institution in confirming or appointing arbitrators, as well as also the role of the institution in screening or in scrutinizing awards, was a legitimate refusal by the institution. And another example is Article 12.8 of the ICC rules, which is appointment of arbitral tribunals in multi-party arbitration. This is the provision that allows the institution to appoint all members of the tribunal in a multi-party scenario to avoid the risk of an imbalance or of inequality between the parties with respect to the constitution of the tribunal. My conclusions are that institutional rules are drafted by bodies of arbitration specialists, so they are thoroughly thought through. They are based on the institution's experience and practice in administering numerous arbitrations. Therefore, the parties should be very careful in amending or modifying the rules. When the parties introduce modification to the rules, this should only be in cases where this responds to parties' genuine needs. Our lawyers tend to be creative. They want to change also what has been drafted by an institution. I would submit that it is generally not advisable. And my last point would be that institution should not be too deferential to party autonomy. There are situations in which party autonomy probably doesn't deserve to be respected in all cases, particularly when this would be against the parties' interests themselves, particularly because this may lead to an unworkable arbitral process, and I've given some examples in the little time available, or in certain cases, particularly when the amendments go against express terms of the arbitration rules, this may lead to invalid or unenforceable awards. Thank you very much.